Chicago, Illinois, early aughts. Two men meet at a bar. They go home for a nightcap. One ends up stabbed to death over 60 times. The other survives. What happens next? Let me give you a hint. The one who survives is charged with first-degree murder. He hires a good defense attorney who says it was self-defense. They convince the jury lets him go, and long story short, I'm not good with hints. Sometimes the criminal justice system...
It was more like guilty until proven innocent.
...isn't all that just. Which stage of sleepwalking involves murder? That's scary.
Of course it is.
You don't give up, do you?
I'm Jena Friedman, and this is Indefensible.
This man was accused of killing a man. He stabbed him 61 times. He said it was self-defense.
61 stab wounds. Does that sound like self-defense to you?
In this episode, we'll examine a case that pushes the boundaries of what constitutes self-defense. Just a note before we begin, we're not naming the killer in this case, mostly because our show isn't about him, it's about the insidious defense that enabled him to walk free. But also because he is still free, and that's just scary. So what happened? On March 5th, 2008, Officer Jason Curry is dispatched to the Alexian Brothers Hospital in Hoffman Estates.
That night, I was on patrol, and I received a call in reference to a stabbing.
911. I just wanted to report that my boyfriend, he was stabbed.
Once I made contact with him at the ER, the boyfriend advised me that he was attacked by another man.
The man being questioned by Officer Curry sustained minor wounds. When you encountered the subject at the hospital, what did they tell you?
Who do you mean by they?
The subject. I'm trying to be gender neutral. Sorry.
Gotcha. He said that he had met Mr. Hauser at a local bar. Mr. Hauser invited the subject over to his apartment for some wine. He said that once they got there, Mr. Hauser was showing the subject a knife and sword collection that he had. The next thing he knew, Mr. Hauser took one of the knives and attacked him with it.
But there's more to the story.
Now, while he's telling this, I was hearing on the radio that there was another victim found at the scene.
Officer Curry soon realizes the man at the hospital thought to be the victim might actually be the attacker. When police arrive at the scene, the inside of the apartment shows no sign of a struggle. Even the wine glasses are still set neatly on the table. Officers also find the other man, dead. The victim is identified as 38-year-old Terrence Michael Hauser, a single dad known to family and friends as Mike.
For months, we're wondering what happened. What happened? We know it was a saber and it was a dagger. It was part of Mike's Renaissance Fair costume.
What did you think the motive was?
Oh, I have no idea. I couldn't see one. I see my dad, who is super sociable, the greatest friend to anybody and everybody. I mean, my dad was my joy. He taught me video games, how to go out camping, and he was living his life.
Mike made friends easily, and Mike was a social guy, and he just made friends with the wrong guy.
That's the kind of guy he was. He was warm, loving, he cared about family. He was just so happy to be a dad.
In the aftermath of Mike's death, police arrest his killer and charge him with first-degree murder. It seems like an open and shut case.
We have, suspect, we have weapon, we have body. It's a slam dunk.
It's a slam dunk.
Those are
you're
thoughts
exactly
going through my
right.
head.
Right. And then what happened?
We just got out-lawyered.
Out-lawyered by Sam Adam Jr., one of Illinois' top criminal defense attorneys, who has represented such upstanding citizens as Rod Blagojevich and R. Kelly.
The state's attorneys, I really feel like they weren't prepared for this defense coming up because, man, I sure wasn't.
So what was this defense?
The phrase gay panic never arose during the criminal trial, to my recollection.
Whoa! Who said anything about gay panic? At the trial for Mike Hauser's murder, the defense throws a bit of a curveball. Reporter Barbara Vitello, who sat in on the trial, recalls the defendant's testimony.
He claimed that Mike Hauser threatened to sexually assault him. He said a struggle ensued, and during that struggle, Mike Hauser was stabbed 61 times. And so he claimed that it was self-defense.
Do you think that that impacted the jury?
Well, as a reporter, I'm reporting what happened during the criminal trial. I'm not there as a commentator, so I have to just address the facts.
And for people watching in America in 2021, what are facts?
Well, in a criminal case, they are that evidence which the prosecutors and defense attorneys submit and which a judge allows into trial.
So how does this count as evidence?
The defense made a point to, I think they had Conan the Barbarian on the TV, the wine, you know, the wine glasses. It's effeminate to drink wine in long-stemmed wine glasses.
The defense attorney played on arbitrary stereotypes to try to paint a picture of Mike to feed his story.
Yep.
I thought to myself, this has got to be a, switch in identity here. Mike wasn't gay, and this is a mistake. And I hold our state's attorneys accountable for not speaking up, for not having Mike's girlfriend on the stand.
Why didn't they have her testify?
They didn't think they needed it. They thought they had it slam dunk.
With no signs of a struggle and little evidence supporting self-defense, you'd think this would be an easy case for the prosecutors. But then the defense attorney did what good attorneys do. He appealed to jury bias.
He asked the jurors to imagine that all the facts in this case were the same, except the defendant was named Josie. It was a rather bold approach.
The defense attorney told the jury, I'm going to swap out this male defendant, put in a woman. Now, how do you feel about this person's guilt?
Right. And then the jury deliberated for about 5 hours, and they acquitted on charges of first-degree murder.
So this is like the one instance where the female lead reboot worked.
Jurors only had the option of either convicting the defendant of first-degree murder or of acquitting him of the charges.
That makes sense, as there's an extremely high bar for convicting someone of first-degree murder. All the defense had to do was associate the victim with homophobic stereotypes, evidence, to sow reasonable doubt and sway the jury.
It hit me like a brick. It was just kind of, wow, he got away scot-free.
Absolutely no punishment.
Because the defense was able to insert this homophobia, or whatever you want to call it.
Right. It's what it is.
Somehow that resonated with the jury.
Subconsciously, I told myself, okay, this happened, it's over, this is the ruling. And at 12 years old, you can't rationalize it like I can now, to where, okay, you know what, it's in the past, let's honor my dad as he was and show my family who he wanted me to be. And I put on this happy mask of, I'm okay, I'm great, everything's fine. And
I'm trying not to cry on camera.
it kind of looked like that. It was a happy mask.
You just set me up. You just set me up to be able to use this horrible prop that we made at the last minute. Thank you for doing that.
Yeah, and
with little else to go on, in order to support the defendant's claim of attempted assault, the defense had to imply the victim was gay. And while merely calling someone gay should never be enough to support an unsubstantiated claim of attempted rape, in this case, it somehow worked. So how did that happen? Proving self-defense in a violent attack can be pretty tricky. In such cases, defenses sometimes turn to a strategy that goes by multiple names, but is rarely ever called what it actually is. Professor of Criminal Justice and researcher Karsten Andreessen explains.
The gay panic defense invents a motivation to justify deadly violence. It can show up in one of four ways: self-defense, insanity, diminished capacity, and then provocation.
How do we articulate such a nuanced, complicated issue in 20 seconds?
Right.
Gay panic defense, what is it?
I kill a man, and I said it's because he made an advance at me.
Is that a confession or a description of the gay panic defense?
It's a description of the gay panic defense.
Okay, so what are some factors that differentiate self-defense from a gay panic case where somebody would claim self-defense?
Often in a straight-up traditional self-defense case, the person is shot or stabbed 1 or 2 times. What you see with gay panic cases or trans panic cases is that there is an extreme amount of force used. If you see somebody that is stabbed 30 times, 60 times, there's one case where somebody stabbed somebody 200 times. That level of overkill has historically been linked to biased killings of gay men.
One of the most well-known cases where the gay panic defense was used in the U.S. involved an incident that happened in March of 1995 during a taping of The Jenny Jones Show. 24-year-old Jonathan Schmitz was invited on the show to meet his secret admirer. But once he discovered that his admirer was a man, everything changed. Weeks after the show, Jonathan Schmitz shot and killed his male admirer, Scott Amador. Schmitz's attorney used the gay panic defense in court.
But have you ever been really embarrassed on national television when you're worried about what everybody's going to think of you as a person? I think any reasonable person could snap.
But other times, such as Mike Hauser's murder case, the defense is less overt.
A defense attorney doesn't say, hey, I'm going to use the gay panic defense. It operates at the level of cognitive bias. The jury is not aware of their own biases.
So how often do these defenses show up in courtrooms? Well, part of the problem is that we don't actually know.
There's no federal or state registry that tracks every time a gay panic or trans panic defense is used.
Why is our government not tracking cases where gay panic defenses are used?
America is unfazed by homicides. America is not concerned about gay people being murdered. America is not concerned about mass shooters shooting up elementary schools. We just don't care about homicide, and we don't track these things.
Do people often walk away from you at parties?
Of course they do.
In recent years, there's been a nationwide movement to outlaw the use of the gay panic defense. In fact, as of fall 2021, 15 states and Washington, D.C. have already banned it in court. But not everyone is keen on outlawing the gay panic defense. Who would ever be opposed to banning a defense that perpetuates homophobia? Public defender Alice Fontier.
I do not believe the gay panic defense, to the extent that exists, should be outlawed. It feels bad, is why it is there's a movement to ban the defense, because it feels like what you are saying is, I should not be held accountable for my actions because of my homophobia. And that's not the defense.
The defense is, I should not be held accountable for my actions because of the jury's homophobia.
No, but there is a root of homophobia, of course.
Is homophobia a valid defense?
No.
But a reaction triggered by homophobia is a valid defense?
Potentially, depended on the circumstances, and the jury would have to decide that your reaction was so extreme and triggered in such a way that your actions that stemmed from that triggering event were reasonable.
All right, I'm trying to wrap my head around lawyer speak.
The nature of the defense is that in that moment, for whatever reason, you didn't have a rational, thought-patterned reaction. You had an extreme emotional reaction. The jury has to say, was the fear reasonable? And if the jury does not think that your reaction was reasonable, then they're not going to find self-defense and you will be convicted.
So you want the juries to be able to determine what self-defense is and what it isn't?
Correct.
Not the law.
In the circumstances we're talking about, I want the jury to make those determinations, yes. It is a belief in the jury system and a belief that 12 people should have a final say and not one politician. You want me to high-five you for that?
That's funny.
I do actually believe in the jury system, though.
I'm sorry, that's really funny. If the gay panic defense is taken out of courtrooms, how will that change juries' perceptions?
It just means you wouldn't present the facts. The jury will never be told this could be extreme emotional disturbance.
So juries need to be able to hear what the defendant felt their motivation was.
I mean, it's the best way to understand what somebody meant to do is to hear what motivated them.
Defendants almost need like a safe space to be homophobic.
No.
Do you believe any defenses should be outlawed?
No.
No defenses should be outlawed?
Correct.
What about a racially motivated defense?
I mean, there are, when you look at like self-defense and you're talking about somebody, a white person and who killed a black person in Alabama in the 50s, that probably was a defense that would be used. And times change, but the law of self-defense doesn't change. We didn't ban people from saying, a black person walked onto my lawn, so I thought I would be killed and I shot them. We just, juries.
Changed it.
We don't change it. The juries say, that's not reasonable.
That's not reasonable to use a race defense. We're gonna call it stand your ground.
That's a good point. And again,
sorry, wait, what did you just say?
I said that's a good point.
Okay, so back to the gay panic defense. So this law is basically saying, as a society, we're gonna have a zero tolerance policy to your transphobia or your homophobia or your extreme emotional reaction to someone else's existence.
That's exactly what it says. That's correct.
Cool. It gives me hope.
I understand that. And it is, I am, just to be totally frank, I am a gay black woman. I don't, and so this isn't about me and my personal beliefs or a tolerance of homophobia. It's about the right to a defense, and it should be available regardless of the circumstances that caused you to have that.
I'm glad that you're fighting the fight and that you're out there protecting vulnerable people who kill gay people.
And everyone else who is accused of a crime.
Luckily for Alice, even if the gay panic defense were outlawed in every state, as we saw in the case against Mike Hauser's killer, all a defense attorney has to do is imply gay panic for it to be effective. So then, why ban it at all?
A society communicates its values by the laws they have. And the gay panic and the trans panic defenses and sort of everything behind that is so terrible that if you have a law, it puts everybody on notice. We're not going to tolerate that.
Are heavier sentences incentives for murderers to be less murdery?
I don't think it'll make murderers less murdery, but it will have them getting acquitted less.
It's better than nothing.
It's the best it is better than nothing.
Although the jury failed the Hauser family in the criminal trial, a different jury ruled in their favor after the family filed a wrongful death civil suit. While no amount of justice could ever bring Mike back, his family was awarded $600,000 to be paid by the defendant. But to this day, they have not received a penny. Maybe we'll never be able to legislate homophobia, transphobia, or other hate out of society, but the least we can do is ban the legal justification of it.